Okay, let's unpack this. In a world overflowing with information where, it often feels like we're just tiny cogs in this massive impersonal machine, what if that machine has forgotten its very origins? What if the foundational unit of society, the family, holds a profound power that has been, well, systematically overlooked, maybe even suppressed? Welcome to the deep dive. Today, we're plunging into a truly provocative concept: the family as a sovereign entity. A primary legal personality that, according to Bellis, not only predates, but in essence is superior to the state. We're exploring insights from Bellis's compelling work, Origins, a Family Manual of Governance. And this isn't just a book you read, it's really presented as a detailed blueprint. A blueprint for families to reclaim their constitutional sovereignty and fundamentally redefine their relationship with government. Our mission today is to distill the core arguments, the practical strategies Bellis puts forth, giving you a shortcut, basically, to understanding a revolutionary perspective on family, state, and law. You might just have a few aha moments along the way.
Yeah, what's truly fascinating here is how Bellis doesn't advocate for like a rebellion against the legal system. Not at all. Instead, he proposes a meticulous rereading and reapplication of its highest laws. It's about recognizing inherent rights and responsibilities already embedded, in the Constitution and international law. Rights which have been largely forgotten or perhaps deliberately obscured. So this deep dive offers not just surprising facts, but a comprehensive framework for what he calls procedural judo, using the system's own rule, its own highest laws, against its current, often, well, unconstitutional practices.
Right. So, if you're ready to navigate the complexities of state family interactions, if you're curious about reclaiming autonomy and want to understand the true hierarchy of power from a completely new angle, you are definitely in the right place. Let's dive in. Okay, so to really understand this groundbreaking perspective, we need to start with the source itself. Origins, a Family Manual of Governance. I mean, the title alone hints at a profound reevaluation of fundamental structures. Can you tell us a bit about Bellis and the context of this work, especially its publication date, September 2025? It feels very strategic, almost like setting the stage for something.
It absolutely does feel strategic. Michael Bellis holds an MSc based in Ljubljana, published Origins in September 2025 through the Bellis Society for a Happy Life. And from the very first glance, the book makes a pretty bold statement. Bellis chose a self-recorded ISBN, explicitly noting it's not for state record. Now, this isn't some subtle detail. It's a foundational declaration of independence right there on the cover. It positions the work not as, say, a commercial product seeking state validation, but as a grassroots tool. It's challenging conventional state-sanctioned legitimacy right from its inception. It's a clear signal that this work is intended to operate outside or perhaps, above the usual governmental frameworks,
Hmm.
right from the first administrative act of its existence.
And the copyright notice really underscores that intention, doesn't it? It states the copyright is explicitly for the public good. Concepts and tools designated for every family, single mother, father who chooses to assert their constitutional sovereignty. That's a truly revolutionary move, effectively giving away the intellectual property for collective empowerment.
Precisely. It transforms the book from like a traditional commercial item or even a political treatise into a practical open source manual for collective action. This generosity with the copyright really highlights Bellis's core mission to provide an operational kit for self-governance and the reclamation of inherent rights, rather than seeking profit in a traditional sense. It's about empowering people to act on this knowledge.
Okay, this leads us directly to the book's fundamental thesis. And this is where it gets truly paradigm shifting. Bellis asserts that the family is not merely the basic unit of society, but rather the original, primary, and sovereign legal entity. The book literally states the family comes before the state. Without family, there are no people. Without people, there is no state. I mean, this isn't just a philosophical idea, it's a radical legal assertion. It fundamentally flips our understanding of governance, putting the family right at the top of the hierarchy.
Yes, and what's incredibly insightful here is how Bellis meticulously deconstructs the conventional view. He argues the family is the original, primary, and sovereign legal entity. Its authority, its very existence, transcends the state. He explicitly rejects the notion that the state creates the family. Instead, he points to Article 53 of the Slovenian Constitution. It says the state merely protects the family. And this protection, Bellis contends, implicitly recognizes the family's pre-existing, independent, and frankly superior nature. Think about it. You can't protect something you created. You protect something that is independent, maybe even sovereign to you.
So Bellis traces this back historically. He's saying the family wasn't just a social construct back then. It was effectively the first economy, the first court, the first school, even the first form of governance, long before written laws or kings.
Exactly. It was the original microstate, in essence. And he highlights this crucial distinction between natural and artificial entities. The family, he argues, is a natural entity, born of inherent human connection, social existence. It doesn't need state registration to exist. Unlike state-created fictions like companies, associations, or even the state itself. These artificial entities exist only when registered by law, and they're inherently limited by those laws. Bellis aims to dismantle what he calls the hierarchy of fiction. That's the illusion where the state sits at the top and the individual or family is pushed to the bottom as these atomized, manageable units. It's about exposing that illusion and reestablishing the true, natural order where living beings organized into families are sovereign.
That makes a lot of sense. So the book's mission then is to reverse this blind reference we've all been operating under. It wants to force state officials to actually demonstrate their compliance with a constitutionally based family act, rather than just hiding behind that blanket statement, we act in accordance with the law. The burden of proof gets flipped onto the state.
Right. And this raises a really important question. How can the state justify its actions if it's just an artificial construct without inherent human rights? Bellis posits that the state, as a legal fiction, finds itself in evidentiary distress when it's in dispute with a family. It cannot prove a violation of rights that it, as a fiction, doesn't actually possess. This is a crucial point. The state, he contends, was established by the people, organized into families, specifically to protect their rights, not to curtail them. This perspective elevates the whole relationship to a new constitutional doctrine. Family rights are original, natural rights of the legal entity. And these reinforce, rather than nullify, individual human rights. So the book systematically presents knowledge of the Constitution not as some passive understanding, but as an operational manual. It's designed to expose this systemic schizophrenia where the state formally celebrates its constitutionality, but practically acts as if it doesn't exist.
So what does this all mean for you, the listener? It means moving beyond just, complaining when something feels wrong, and instead being equipped to challenge the system on its own terms, using its own highest legal framework. It's about becoming proactive guardians of your own family's sovereignty, empowered with this knowledge.
Exactly. It's not a collection of grievances. It's fundamentally an empowerment tool. Bellis argues that the state has consciously created an illusion of control over families, which brings us to his diagnosis.
Yeah.
How did we actually get here? How did the family's inherent sovereignty become so obscured?
Bellis's analysis is like peeling back layers of an onion, isn't it? Revealing deliberate strategies that shifted power away from the family, hiding it behind illusions of necessity and technicality. The first illusion he identifies is what he calls the naming monopoly.
Right. He argues that the state gradually assumed a monopoly over language and, by extension, reality. It reduced the marriage certificate, which he sees as this public document witnessing the birth of a new sovereign legal entity, reduced it to a mere sentimental formality, just a piece of paper. At the same time, it elevated artificial acts, like company registration, as the only valid economic acts. This, Bellis contends, fractured family integrity, and monopolized legitimacy. It effectively reduced the family to just a collection of taxable, controllable individuals, rather than a self-sufficient, sovereign economic unit.
And then there's the necessity illusion, this idea that you need these fictitious legal forms like sole proprietorships or limited liability companies just to survive economically.
Yeah, and this is presented as a subtle but really powerful mechanism for transferring sovereignty. When a family member sets up one of these entities, they unwittingly pledge their family's primary real property as collateral for an artificial creation. This, Bellis warns, opens the door wide to state control over constitutionally protected privacy. It subjugates what the family already possesses rather than facilitating new independent ventures. It's a trick of control, he argues, disguised as a necessary business formality. Wow.
Beyond these illusions, Bellis details what he sees as a deliberate intrusion into the Constitution itself. He cites the startling decline in print numbers of the Slovenian Constitution, from being widely available back in 1999 to only 150 copies in 2024, effectively turning it into a hidden, forgotten document. It was designed, he says, as a shield for the sovereign family, but it became an inconvenience for those in power.
And the judicial system, he argues, played a significant role in fostering what he calls systemic schizophrenia. Courts began interpreting the Constitution through subordinate laws, effectively reversing the clear hierarchy established by Article 153. Article 153 explicitly states the Constitution is supreme. The result is a state that formally celebrates its constitutionality, but practically disregards its highest law, creating this fundamental disconnect.
And the recent pandemic tragically became, as he puts it, a perfect testing ground for this kind of intrusion. Remote work, homeschooling, while presented as necessities, Bellis describes them as a Trojan horse, designed to penetrate the homestead, blurring public and private boundaries. The family, in this view, became an unpaid contractor of government tasks. Parents as supervisors, children exposed to unprecedented digital surveillance. This, the book suggests, foreshadows a future of central management with no clear borders between public and private life, potentially leading to total control.
And this connects directly to Belz's most forward-thinking argument, I think. It's found in the section targeting artificial intelligence for government. He proposes actual corrections in the legal code of the state administration, urging programmers and government architects to delete the original error in the operating system country. Specifically, he recommends transforming the physical person entity, which is currently, a standalone root entity in state databases, into a subordinate object tied to the pravna oseba, meaning the family as a legal entity, via a foreign key. A one-to-many relationship. This, he argues, would accurately reflect the constitutional hierarchy from Article 153. It's essentially a call for a digital fix to a constitutional problem, a rewrite of the digital code to align with the true legal order.
That's a really sophisticated argument, isn't it? Connecting constitutional law to the very architecture of digital governance. It truly drives home the idea that Bellis isn't just about protesting, he's about fundamentally rewriting the code, both legal and digital, to put the family back in its rightful place. So if we accept Bellis's premise, what's the blueprint for action? The book provides a complete plan for the family's legal framework, starting with this audacious concept of a family act, essentially a constitution for your own microstate. What exactly is this? And more importantly, how does Bellis argue it makes the family's law legally binding on the state? Because that's the key, right?
Right, that is the absolute key. And what's truly revolutionary here is the idea that every family has a constitutional right, derived explicitly from Article 53 of the Slovenian Constitution, to write its own law. This isn't presented as some illegal act, but as a consistent and full exercise of guaranteed rights. It makes the family a constituent for its microstate. The Family Act itself is described as more than a statute and not just a law. It's a declaration of already existing unlimited action in all areas of society. It asserts the family's inherent nature as a partnership, an association, an institution, and more explicitly rejecting state attempts to categorize it into these narrow, manageable roles. And crucially, Bellis argues that by creating and properly publishing its own law, the family shifts the burden of proof entirely to the state. Any state authority seeking to interfere must then prove its intervention is legitimate and constitutionally permissible, despite the family's validly published law, which effectively becomes the primary source of law for that family.
So it completely redefines the legal playing field. It turns the state's own defense, we act according to the law, right back on them. If the state always acts according to law, and the family now has a valid, constitutionally sound, published law, then the state has to respect it. Okay, what are the practical steps then? How do you establish and proclaim this family sovereignty?
Bellis provides very practical, concrete steps. The first is the codification of internal order by creating your own family law. This involves convening all adult members for an inaugural meeting of the Family Council, treating it as a formal act, much like a founding convention. The entire family law must then be read word for word, clearly and aloud. This ensures every adult member understands, internalizes, and consciously accepts it. It's crucial for joint affirmation of sovereignty, not just an imposition from, say, one person.
And unanimous consent is vital for that internal legitimacy, right? Reflecting the collective will of this newly formalized sovereign entity.
Absolutely, that's key. The document outlines the basic principles: managing joint property, decision-making procedures, mutual care, data protection for members, conditions for legal relations with outsiders, including the state. Bellis even provides a detailed model, Entire Family Act, DZZPPO, in Annex A of the book. So families have a template to adapt, making it accessible.
So it's not just making rules then, it's about formally codifying them. Creating a living constitution and a detailed historical record, almost like a microstate would, this requires establishing a proper legal memory, as he calls it.
Precisely. Bellis insists on that. A single, carefully organized place could be a physical notebook with numbered pages, or a secure digital folder must be designated for storing minutes and decisions of the family council. This creates a collective legal memory. Each decision needs a standardized format, an order number like DS202401, date, clear content, and indication of unanimous acceptance. This meticulous record-keeping underpins the family's authority, and as you hinted, the Family Official Gazette becomes the core of this legal memory, especially for external validity.
Okay, here's where it gets really impactful. The idea of a family official gazette. What a powerful way to assert public knowledge of your family's laws. It's like saying, these are our rules, world, and you're now officially aware of them. And it transforms internal decisions into publicly valid laws that the state must acknowledge.
That's exactly the argument. It's presented as more than just an administrative task. It's a cornerstone of sovereignty. Any decisions with external implications, appointing a director, economic agreements, rejecting an unconstitutional state act, must be published in this Family Official Gazette to achieve unquestionable public validity. The book calls it your mouthpiece of freedom, clearly and unambiguously setting out the rules, principles, actions of your family as a primary legal personality. It essentially makes your family's law published law.
And this act of publication, Bellis argues, grounds itself directly in the existing Constitution. It's not just made up.
Oh, absolutely not. He draws legitimacy directly from Article 154 of the Slovenian Constitution, which stipulates that regulations must be published to enter into force without explicitly tying publication to a state-owned newspaper. That's the loophole, or rather the overlooked right. He further references international law, like Article 10 ECHR, Article 11 Charter of Fundamental Rights of the EU, guaranteeing freedom of expression and media. Bellis emphasizes that public availability online fulfills the principle of legal certainty, meaning no one, including the state, can claim ignorance of the family law. This echoes rulings from the European Court of Human Rights and the Slovenian Constitutional Court on Information Access. By publishing, the family transforms from a passive subject into a legislator, a publisher, and a guardian of your own order, leaving no room for doubt on your determination. This is the core of how the Family Act becomes a law, that the Slovenian government, which always states we act according to the law, must then respect, because it is law fully aligned with the Constitution.
Okay, so once a family has its own constitution and its own official gazette, the next step in this blueprint is economic liberation. The book calls it freedom surgery. Sounds quite dramatic, but what's the underlying strategy here?
Well, it's a concept designed to strategically break financial dependence on what Bellis calls the fictitious state.
Hmm.
He argues that these fictitious legal entities, the SP, the DOO, are merely channels through which the fictitious state controls and, frankly, exhausts the primary legal personality of the family. So freedom surgery is this precise, deliberate process to separate the family's real personal property from these bureaucratic shells, thereby breaking dependence on the state system. It's framed as liberation of value, not destruction. And it's deeply grounded in constitutional pillars like Article 49, guaranteeing freedom to work, and Article 74, guaranteeing a free economic initiative.
So this is a strategic retreat then, an exodus, but not to another country. It's about creating sovereign economic territory within the existing one, allowing the fictitious state to kind of dry up by redirecting economic activity away from it. What are the practical steps involved in this surgery?
The first crucial step is a formal legal transfer of ownership. Bellis highlights that the Family Act itself already stipulates that all property created by the work of family members is the exclusive and inviolable personal property of the primary legal personality of the family, protected by Article 33 of the Constitution. This principle is then formally enforced through an internal family council decision. The decision finds that specific property, even if currently registered under a fictitious entity like an SP, is in fact the personal property of the family. The fictitious person was merely a temporary manager, not the ultimate owner. This legally reattributes ownership back to the sovereign family entity.
And then you move to close down those fictitious companies.
Yes, that's the first cut of freedom surgery. It involves closing all secondary fictitious companies that family members were, in Bellis's view, forced to establish. But crucially, before closure, all contractual obligations and debts incurred within the fiction must be honorably settled. Bellis stresses this demonstrates the superiority of the family's value system, prioritizing integrity. Once empty, no assets, no debts, a formal process is initiated to delete the entity from state registers, like AGPIS in Slovenia. This is seen as a technical act of terminating a subordination agreement and, as Bellis puts it, a day to celebrate for the family's autonomy.
But what about assets where the state might have a claim, maybe through past subsidies or something? You can't just close those down directly without inviting intervention, surely.
That's where the management of neglected assets comes in. Bellis calls it a strategic chess move, empty in silence and bypass. For fictitious shells where the state has become a co-owner, say through subsidies, direct closure is avoided. That would likely trigger intervention. The strategy is to leave the infected shell to formally exist, but make it entirely irrelevant. A new, unencumbered legal entity, perhaps in cooperation with another sovereign family, is established for a transitional period. This new shell functions as just a technical interface, free of problematic assets and history. The infected shell then enters into a business cooperation or transfer agreement for know-how, customers, etc., with the new, clean entity, legally transferring the real value to the new environment. The old shell's activity is then reduced to minimal costs until it's economically viable to either shut it down or maybe buy out the state's share. This achieves what Bellis calls the great separation. Real value stays with the primary legal personality, and the fictitious state is left holding empty, useless bureaucratic shells starved of economic substance.
Wow. This is a remarkably detailed roadmap for creating an independent economic ecosystem. It also introduces the concept of direct contracts between sovereign families. How does that work?
Yes, indeed. These contracts form the foundation of a new, free economy, explicitly bypassing state regulation of companies. They're based on civil law principles: autonomy of will, mutual trust. Bellis provides a model agreement, a cooperation agreement between primary legal entities. It would specify, say, Family A and Family B, represented by their directors, using their marriage certificate registration numbers as their primary identifiers. It details the subject of cooperation, the value, payment methods, perhaps through central treasuries established by families, and dispute resolution, like an honorary family tribunal or ad hoc arbitration. This is all explicitly based on constitutional rights: freedom to work, Article 49, freedom to conduct business, Article 74, emphasizing that the freedom to work is much broader than just state-defined employment, and mutual assistance between families shouldn't be labeled undeclared work.
And instead of relying on state tax accounts and invoicing, families are encouraged to keep their own internal value records. Is that right?
Exactly. This is presented as a refusal to participate in a fictitious, state-controlled system, not as tax evasion. Each family archives its own transparent records of value generated, along with copies of proofs and contracts as part of its business records. This demonstrates economic activity and transparency within a constitutionally guaranteed free labor network, without relying on state tax accounts. It really seems Bellis anticipates every move the state might make to try and maintain control over a family's economic activity, and offers a strategic counter for each one.
Okay, so this all culminates in a huge paradigm shift. The family moving from just being a collection of individuals to becoming a unified, legally recognized institution. Bellis argues that through this process, the family becomes a sovereign microentity capable of negotiating with the state on an entirely different footing.
Yeah, if we connect this to the bigger picture, this is absolutely about reclaiming the original hierarchical order. Family is creator, state is creation. Bellis asserts that upon its official registration, through the marriage certificate as the primary act, and then the family act, the family transforms. It goes from being a mere collection of individuals into an official community and a recognized primary legal personality. This newly asserted status means the family can now interact and negotiate with state institutions, municipalities, ministries, the government itself, as an institution, akin to a microunit. And it possesses qualities that Bellis argues exceed those of any state-registered fictitious legal person. The key distinction he makes is that state-created fictions are limited by their statutes and laws, whereas the family, deriving its authority from natural law and the Constitution, is presented as unlimited in its scope and inherent rights. By formalizing its internal structure and publishing its Family Act, the family asserts this primacy. It moves beyond being a subject, becoming, in a sense, an employer of the state.
Okay, this is a lot of legal depth, I get that. But Bellis essentially decodes the Constitution as this powerful firewall, specifically designed to protect living people and their families, not merely a rule book for citizens. It's like discovering the cheat codes for the system. He points to numerous articles of the Slovenian Constitution and international law as the legal bedrock for the Family Act, granting the family unlimited authority that, once codified in the Family Act, essentially transforms those constitutional rights into enforceable law for the family.
Indeed, he lays out a truly comprehensive legal arsenal. Bellis meticulously leverages key constitutional protections. They form the very framework of the Family Act, ensuring it is, by its nature, fully compliant with the highest law, Article 153. He builds this formidable legal shield using principles like foundational sovereignty, Article 3, power vested in the people, family as the fundamental unit, property protection, Article 33, guaranteeing private property, shielding family labor from illegal interventions like calling it undeclared work, bodily autonomy, Article 35, inviolability of physical mental integrity, limiting state intervention, inviolability of the home. Article 36, ensuring the home is private, immune from state demands like forced remote work schooling setups. Freedom to work. Article 49, interpreted broadly as the right to create value, establishing the family as a free enterprise. Family protection. Crucially, Article 53, the state protects the family, implying its pre-existence and independence. It's the only institution with such direct constitutional protection. Parental right to education. Article 57, upholding parents' primary right, positioning schools as a service. Limits on expropriation. Article 69, property only taken in public interest with due process. Free economic initiative. Article 74, reinforcing the family's capacity for autonomous economic operation. Official accountability. Article 120, officials must act based on Constitution and laws, refusing unconstitutional orders. Self-governance. Article 145, right to unite in self-government. Family is the most natural form. Hierarchy of law. Article 153, Constitution Supreme. The guillotine for non-compliant bylaws. This allows the Family Act to become binding law. Publication requirement. Article 154, basis for the Family Official Gazette's legal validity. Protection against retroactivity. Article 155, the time lock, protecting original rights from later state changes. Personal liability. Article 26, right to compensation for damages from unlawful official actions, makes unconstitutional actions risky for officials personally. International backing. Referencing UDHR Article 16, ECHR Article 8, reinforcing family as a natural unit needing protection, independent of state registration. Bellis argues the Family Act is entirely aligned with this framework. It's not about regionalizing the system, but a reminder to officials about the violations they consciously commit. Once that Family Act is published, the state must now communicate with the family based on that law, not just target individuals.
That's a huge amount of legal backing to support the family's inherent sovereignty. And it shows how the Family Act essentially transforms these constitutional principles into concrete, actionable laws for the family. So, how does this new paradigm challenge existing state identification and records, especially regarding individuals? Bellis talks about a unique red number on the marriage certificate. What's that about?
Yeah, this is a truly fascinating detail Bellis highlights. He points to this unique red serial number, something like PA0XXXX found on the marriage certificate. He presents this as irrefutable evidence of the primary material registration of the family as a legal entity. This number, he explains, is a unique, unrepeatable key, assigned to the founding event of the family and verified by the state registrar, a core state body. Its permanence and authenticity are contrasted with other black numbers the state uses for administrative purposes. So this red number is positioned as the family's true original identifier. It bypasses the state's commercial fictions, which are for employees or fictitious entities. It's systemically red, visually distinguishing it, emphasizing its foundational sovereign nature.
So, when an official uses your name in all caps or asks for a tax ID, Bellis argues they're essentially talking to your avatar in their system, not to you as a living sovereign person. This is about taking control of that interface and clarifying who they're really dealing with. Is that the idea?
Precisely. Bellis describes how the state, through documents like the Certificate of Citizenship, creates what he calls legal fictions. For instance, first name, last name, in all capital letters. He contends these are just administrative avatars, transcriptions of living people into controllable entities for the state system. These fictions are regulated by statutory laws, while the living man or woman is protected by the spirit of the Constitution. The strategy, then, is to use the serial number of the original Certificate of Citizenship to interact with the system, not as the fiction, but as a party, quote, investigating the validity of the very contract by which the fiction was created. This shifts the individual from being an object in the system to an auditor of the system. It creates, as he puts it, a system short circuit, because officials are primarily equipped to deal with fictions. not living people asserting constitutional rights directly.
And Bellis takes this even further. He really drills down on how digital identity isn't just a convenience, it's presented as the ultimate prison, a complete deception where you pay with your freedom, privacy, and ultimately your sovereignty.
He absolutely frames the state's widespread offer of free digital identity as a profound scam, not a service. He argues it's a cunning means for the state to appropriate the most valuable raw material of the 21st century, your data. You become the product, not the customer in this exchange. Digital identity, he warns, is depicted as a business plan for building a society of total control, where every aspect of life, healthcare, finance, education, even access to food, will be inextricably tied to a digital profile. This digital fiction then becomes your mandatory ticket to societal participation. The family, guided by its Family Act, explicitly rejects mandatory digital identity if it hasn't been introduced by referendum, basing this rejection on fundamental constitutional rights like Article 17, right to life, Article 26, right to compensation, and Article 155, prohibition of retroactive effect, which protects acquired rights like access to health care.
Okay, so once a family understands its inherent sovereignty, formalizes it with a Family Act, and grasps how to challenge state identification and records, how does it then interact with state institutions to assert this newfound status? Bellis outlines specific interaction protocols, starting with a crucial universal notification about the change of status. What is that?
This universal notification is presented as a really crucial operational tool for the family. It's a formal letter sent to all relevant institutions: financial administration, financial institution, administrative units, Ministry of the Interior, Centers for Social Work, Center for Social Work, health insurance institutes, ZZZS, schools, banks, utility providers, everyone. The key is that this is a unilateral notification, not a request for permission. Huge difference. It formally informs the institution of the family's activated status as a sovereign primary legal entity, legally constituted via the marriage certificate, Articles 145 and 53, and now operating under its own published Family Act. The letter demands that all official communications be addressed exclusively to the legal entity family surname, and it warns that any act addressed to an individual member as a natural person, that legal fiction will be rejected as served on the wrong addressee and considered legally null and void. Bellis points out this cleverly leverages Article 66 of the General Administrative Procedure Act, ZUP. That article obliges clients to notify authorities of data changes. So it turns the system's own rules into a procedural judo move against itself.
That is a powerful step. Proactively informing the entire state apparatus about your family's new legal reality, forcing them to acknowledge it or risk their actions being nullified. And instead of an ID card, Bella suggests using a specially designed business card. That seems almost comically simple yet potent.
It does seem simple, but the effect described is potent. The director of primary legal personality, typically the husband and wife, now acting as formalized directors of their family entity, backed by their official state marriage certificate registration, presents this specially designed business card during interactions with officials. The card typically lists family surname, the position director, the marriage certificate number as the family's true original registration ID, and key constitutional articles like 3, 49, 53, 120, 153, 154 that form the operational basis of the family's actions. This simple action, Bellis argues, is designed to completely change the dynamic of the interaction, transforming it from a subordinate applicant seeking mercy to an equal, if not superior, negotiator or auditor. It's like carrying your own mini-constitution in your pocket, instantly shifting the power dynamic. Bellis portrays this as an invisible but omnipresent authority that reshapes any interaction.
The book then details even more advanced protocols for legal defense and offense, describing it as a legal war waged with constitutional arguments, where the family takes on the role of a legal strategist.
It emphasizes a multi-pronged approach, definitely. First, oral confrontation. The moment an official insists on an unconstitutional rule, the family director immediately confronts them with their own supreme law. Questions are sharp as a blade, grounded in the Constitution. Are you aware Article 53 obliges you to protect my family, not obstruct it, especially when our Family Act, based on this very article, is officially published? The goal is to create a verbal record, ideally have witnesses, the official's constitutional duty. Second, a written objection and notification. Within 24 hours of an unsuccessful oral confrontation, a formal letter is sent. And crucially, it's sent to both the institution and the official personally. For example, Financial Administration, Mr. Janice Novak, Tax Inspector. This letter details the unconstitutional conduct, reiterates the legal arguments, Articles 53, 120, 153, 154, 26, and issues a deadline, say 8 days, to remedy the illegality. And it explicitly warns of personal and material liability under Article 26. Third, an objection to null and void act is filed if an official continues to ignore the family's new status and addresses an act to a natural person, rejecting it as null and void because it's addressed to the wrong entity, the fiction, not the primary legal personality, and thus violates constitutional rights.
And then the ultimate legal battleground, litigation. Bellis even talks about escalating to the European Court of Human Rights if domestic avenues prove fruitless.
Yes, Bellis proposes a very sophisticated litigation strategy, that procedural judo again. Families are instructed to document everything meticulously written communications, official notes of oral conversations, all decisions, orders, judgments. The goal is to demonstrate a pattern of systemic refusal by various state authorities, admin units, financial institution, Center for Social Work, courts to respect constitutional rights, and the family's legally published Family Act. Bellis argues that domestic courts often act as biased arbiters, nemo edexing causa sua. No one can be a judge in their own case when the system itself is effectively on trial. Therefore, the ultimate escalation is to the ECTHR. He suggests filing a conditional constitutional complaint with a revolutionary clause. If the decision is negative, the Constitutional Court is instructed to refer its own decision to the ECTHR for consideration. Essentially, a formal action by a state against its own conduct. This creates an impossible choice for the Constitutional Court. It highlights Bellis's consistent strategy, force the state to confront its own foundational documents and international obligations, exposing internal inconsistencies. Make the state accountable as the servant to the master, the family.
And a cornerstone of this entire strategy is making officials personally responsible. Articles 26 and 120 are repeatedly cited. To ensure that an official's signature on an unconstitutional document isn't just a bureaucratic act, but one with potential financial consequences for their personal bank account. That's huge.
It's a serious deterrent and a key lever, yes. Article 120 dictates that administrative bodies and civil servants must act autonomously on the basis of the Constitution and laws, not blind instructions from superiors. If they violate this, Article 26 makes them personally and materially responsible for damages caused to the family. This transforms an indifferent executor into a potential debtor, makes officials think twice about blindly following potentially unconstitutional orders that clash with the family's published law. It effectively turns the system's anonymity into individual accountability, holding them to their highest oath to the Constitution.
To bring this all to life, Bellis includes practical examples like Damjana's story, where these seemingly abstract legal concepts get applied in harrowing real-world situations, transforming a family from victim to enforcer.
All right, Damja's case describes a real-world scenario. State institutions, specifically a Center for Social Work and the state prosecutor, allegedly intruded into homeschooling, forged documents, created an unbridgeable gap within the family, and engaged in systemic self-protection, hiding evidence, biased proceedings, the works. Bellis illustrates how the formalized Family Act acts as a preventative shield before any intervention, asserting constitutional rights related to educational sovereignty, Article 54, inviolability of the home, Article 36, and autonomy of internal relations, Article 53, all now solidified into that family's published law.
So it turns the family from a potential victim into an active enforcer of its own rights. How does the Family act as a strategic counterattack in such a situation?
Well, the family moves from defense to offense. Filing criminal charges against officials damages actions. The Family Act becomes Crown evidence, demonstrating that the officials' actions were a conscious and deliberate attack on the constitutionally protected order, now clearly codified and published. This reverses the burden of proof. It forces the Center for Social Work to provide concrete, material evidence for its actions and a constitutional basis for interference. The family isn't proving its innocence anymore. This blocks manipulative tactics and highlights that personal responsibility under the law. For example, Bellis suggests refusing to attend informal conversations until state officials provide the constitutional basis for their requests, puts the ball right back in their court.
The book even proposes a legally elegant solution for mutual family assistance through a mandate contract, so one family isn't left isolated and vulnerable.
It's crucial, yes. Bellis presents this legally elegant solution where one family, acting as the order taker with its own published Family Act and established legal standing, can legally represent another family, the client, that's under attack through a classic contract of mandate and written authorization. This allows the authorized family to engage with state institutions on behalf of the attacked family. Leveraging its established sovereignty and constitutional defense strategies, ensuring the attacked family isn't left vulnerable, it essentially creates a network of mutually reinforcing sovereign entities.
Finally, Bellis quantifies the cost of oppression for the state, presenting a really pragmatic and compelling argument against state overreach. He makes the case that a rational state simply cannot afford to suppress families who are asserting their constitutional rights in this way.
Exactly. This analysis offers a powerful pragmatic argument. Bellis presents a scenario where the Republic of Slovenia would incur significant costs, financial, administrative, political, if it's systematically oppressed, say even just 50 sovereign families operating under this framework. The direct measurable costs are estimated to exceed 1.2 million in the first year or two alone. That covers administrative procedures, court cases, misdemeanor enforcement, civil, criminal, legal fees. For example, Bellis breaks down potential costs. 125 misdemeanor cases at 300 euro each is 37,500 each. 50 complex court enforcement proceedings at 2,000 euro is 100,000. Maybe 10 criminal proceedings at 50,000 each adds another 500,000. It adds up fast.
That's a substantial immediate financial hit, just for admin and legal fees. But what about the ongoing costs, the long-term damage?
Right, the lost tax revenues for 50 families, assuming maybe 40,000 taxable income per family and a 30% collection rate, are estimated at 600,000 per year, and that's a permanent recurring cost. But beyond these measurable figures, the indirect systemic and political costs are deemed immeasurable but far more devastating.
Mm.
We're talking a permanent loss of state prestige, significant political destabilization, overwhelming the justice system, and the existential risk of this independence movement spreading exponentially once people see it actually working.
So if even one family wins a single point, perhaps getting an official held personally liable or having their Family Act recognized as valid law, it could create a precedent, one that would be impossible for the state to counter without catastrophic consequences.
Yes, exactly. The legal precedent risk is critical. Bellis argues it's enough for a single family to win on just 1 point recognition of primary legal personality and officials' personal liability under Article 26 to create a precedent others can use. The probability of the state winning more than 200 complex court cases without a single mistake is, according to Bellis, practically zero. So the conclusion is that a rational state wouldn't engage in such conflict. The costs of oppression far outweigh any potential benefits. It poses an existential risk to its own functioning. He paints a scenario where the state, by trying to suppress families asserting their constitutional rights through this legally sound framework, would basically be waging a war it cannot win, financially and systemically.
Wow. What an incredibly thought-provoking deep dive. This journey through Melal Bellis's Origins, a Family Manual of Governance, really makes you rethink, well, everything. That fundamental relationship between the individual, the family, and the state, it challenges the very notion of where power truly resides. The core message seems crystal clear. The family, by its very nature, its historical precedents, and by the supreme law of the Constitution, is the original sovereign legal entity.
Indeed. And Bellis moves way beyond mere critique to provide this detailed operational toolkit, from establishing your own family act in official gazette to strategically confronting state institutions, reversing the burden of proof. It's a systematic approach to reclaiming inherent sovereignty. The constant thread is that the state is an artificial construct, a servant. Its authority is limited by the very constitutional framework it's supposed to uphold. This is a crucial call for officials to remember Article 120 of the Constitution, their duty to act independently, on the basis of the highest law, not just internal instructions or outdated protocols.
And it's such a powerful reminder that knowledge of the Constitution isn't just theoretical. Bellis frames it as an operational manual for reclaiming freedom and agency. The book essentially shifts the entire discourse, doesn't it? It's no longer about asking, is the officer's action legal? But about demanding, is the law the officer is acting under even in accordance with the Constitution? And what about our family's own published law, which is constitutional?
Mm.
That question changes everything, turns every interaction into an opportunity to assert sovereignty.
Ultimately, yeah, the message is about empowering individuals and families to transcend being merely citizens, these legal fictions managed by the state, and instead act as living persons, the true masters and architects of their own legal reality. Bellis's vision of procedural judo serves as a necessary defense, really, in a system where officials might have forgotten their foundational duties, guiding them towards becoming smart officials who proactively serve the Constitution and the family rather than just a bureaucratic fiction.
So, as you go about your day, maybe consider this. How much of what you accept as the law is truly constitutional and enforceable, and how much might be an illusion of necessity created by a fictitious state? Bellis urges you to find your own red number, to embrace your family's inherent sovereignty, and to calmly yet decisively ask the question, can you constitutionally justify this, Bellis? Thank you for joining us on this deep dive. Until next time, stay curious, stay informed, and keep asking the right questions.